the curve. And so the privacy right that he talked about in Roe v. Wade isn't even the current law. So as this opinion points out, Roe based its reasoning on this privacy right under the First, Fourth, Fifth, Ninth, and 14th Amendments. But the most recent law, Casey, which refined this case, really relies on only one aspect of the Constitution, which is substantive due process under the 14th Amendment, okay? And so what they tried to do in that Casey decision is sort of wrap abortion into that jurisprudence, which includes all of those other aspects. But as this opinion points out, abortion is fundamentally different. Unlike the marriage cases, unlike these other fundamental rights cases, only abortion stops a human life. And that makes it absolutely unique in the law. And that is why a different analysis needs to apply to it. Now, of course, Justice Thomas did say in his concurring opinion that the jurisprudence that underlies these other cases under substantive due process is also deeply flawed. And you can believe both things. You can believe that people should have the right to contraception. You can believe that people should have the right to abortion. And you can believe that predicating those rights on a flawed 14th Amendment analysis is garbage jurisprudence. And so that's where it needs to go now. It needs to go back to the states. And Tucker, as your whole show has been pointing out, it's much easier for Democrats to create fear and hype and riot. It's also cheaper to make laws by pressuring a handful of justices than by passing laws in the states that the majority supports. And so this is a very sound decision, and I am not losing any sleep over losing any fundamental rights here as a basis of this decision, Tucker.
Well, and by the way, Democrats said they were going to codify Roe in the Congress. They were going to pass a federal law basically restating Roe, and they couldn't even agree on what a pregnant person was. That's the reason it didn't get through. It's like, do you think they can pass a federal law codifying Roe? Why don't they try? I don't understand.
Well, we know why, Tucker. As science has advanced and as people have become more enlightened about this issue and the harms of abortion, there's no majority for a abortion law like Roe. Roe itself is not even the law. But even for Casey, the majority of Americans do not believe that there should be abortion after a fetal heartbeat, after the fetus can feel pain. And that's at the 15-week level of the Mississippi law. The fetus has a developed heart and eyelids and can suck her thumb. That is not something, or a fetus that most Americans believe should be subject to termination at whim. And so they cannot get that law passed. That's why they're hyperventilating and freaking out over here.
Well, exactly. Harmeet, Dhillon, great to see you tonight. Thank you.